In this video, I want to talk about comparative fault. Now, technically speaking, comparative fault simply means comparing the fault of all of the individuals involved. Sometimes there's multiple people that cause a crash, and so comparative fault simply says we're going to divide all the fault up until it reaches 100%. But more of the time, what we're talking about with comparative fault is how much fault does the person that was bringing the case have? Um, what fault, if any, do you have? It used to be, and in some states this is still the case, that if you have any percentage of fault at all, even if it's a tiny amount, you actually can't recover, even if someone else was grossly negligent and caused them, had some majority of the fault for the crash. But in most states, including the states that I practice in, it's some type of comparative fault. Now, pure comparative fault would allow someone, let's say if they are, let's say you're 40% at fault and the defendant is 60% at fault, under pretty much any comparative fault structure, you're going to be able to recover 60% of your damages. So the effect of comparative fault is to reduce your damages. So if the defendant is 60%, you're 40%, your damages get reduced by 40%. In a pure comparative fault jurisdiction, which none of the states that I practice in do that, even if you are 75% at fault, you could recover 25% of your damages from another defendant. But in most states, if you are, let's say, more than 50% at fault, you cannot recover. That's typically the tipping point for most states. Some states it's 51%. Some states it's 50%. So, but right around that 50% mark is typically where you start to worry that you may not recover anything. So, it's really, really important that attorneys be able to gather the information and find out who's at fault, who's responsible, and identify as many responsible parties as possible to put as much fault on someone other than the person bringing the claim to maximize the recovery. So the effect of comparative fault, as I mentioned, is to reduce damages. What are some examples of comparative fault? So it could be simply you're just not being careful when you drive. Maybe you're speeding. You're not keeping a lookout. Maybe you're on your phone. You're distracted. Things like that. Other examples of comparative, and so that's the kind of comparative fault that sort of leads to the crash itself. But sometimes there can be fault that you have that increases your injuries, such as not wearing a helmet if you're driving a motorcycle, not wearing a seatbelt. In most states, it can reduce your damages if you weren't wearing a seatbelt and a seatbelt would have saved your life or made your injuries less severe. A lot of times there's caps, there's a limit on the amount of reduction you can get for that. And a lot of times the defendant actually has to prove not simply that you didn't have your seatbelt on, but that in fact it actually made a difference and contributed to the injuries. So not having a seatbelt on is a common type of comparative fault. Insurance adjusters love any evidence of comparative fault because they can use it against someone to reduce their damages. And if there is a concern that there's a lot of fault on the part of the plaintiff, so the person that was injured. So if they can threaten you that you may have more than 50% at fault, in which case you get zero, they can use that to really leverage people into taking less than the full value of their cases. So comparative fault can be a really, really important concept in most cases.